I welcome you all to lecture number 11 of Clat lecture series. We are doing criminal law basic concepts. These classes are sponsored by Sri Jendra Rank Zone. I am your mentor Shekhar Gehlot. Okay. So in the previous lecture we have discussed what is kidnapping. Okay. So kidnapping, like we discussed, is something which involves kidnapping a minor, and a minor is below 18 if girl and below 16 if boy, and any unsound person. Okay, they are minors. Now suppose someone kidnaps a major person, an adult. Okay, what do we call it? That is called abduction. Okay. When an adult person of sound mind is kidnapped, it is called abduction. We do not call it kidnapping. Why? Because kidnapping is only of kids. Okay, those who are minors or unsound mind. But when similar thing is happening, when someone is illegally, okay, making a, an adult person to go from one place to other, okay, then it would be called as abduction. Okay, but we use the word kidnapping only in the common parlance because it is more general word and people understand kidnapping more easily rather than they understand abduction. Okay, so but the legal term is abduction. Now let us see what section 362 speaks of abduction. Whoever by force compels or by deceitful means induces a person to go from one place to another. Okay, now whoever by force. Now, if we see this abduction in comparison with kidnapping, okay, there is a first word which says this is the first kind of distinction between kidnapping and abduction. In kidnapping, there may not be use of force at all. Okay, but abduction, use of force is essential ingredient. Okay, use of force is essential ingredient. Okay, one of the essential ingredients. There are two ingredients required to commit abduction of an adult person. One is either you abduct someone by force, like we see in the movies. Okay, you go in a car, you put a gun on someone, and you abduct that person. Okay, that is typically abduction, which we see in the movies, abduction by force, or by deceitful means. Deceitful means by cheating someone, committing fraud. Okay, committing fraud, like we see sometimes people issue job advertisements for overseas vacancies. Okay, people distribute job advertisements in papers. Okay, or they obscurely mention job vacancies, jobs required, and this and that, and they put simple pastings on the walls of the common buildings in the area, and they just give a phone number into it, and when someone calls them, they say you are required to work in Dubai as a manager. Okay, as a manager. Later on, it it turns out that person is made a slave there, and menial work is being done by him. Okay, all sort of work they are making him do. They are not paying him. They have confined him. Okay, in the name of the job of manager, they take him and they make him a regular labor. And they beat him as well and they pay him whatever they want to. They do not allow him holidays, or sometimes girls are called for modeling on occasions and put into uh, sometimes what happens, girls are called for modeling, that you come and you join the modeling on foreign location and this and that, and then they are sold as a sex slave. Okay, or they are put into sex trade. So these kind of ways are deceitful, meaning when you say something but you mean something else. Okay, when you say something but you mean something else, that is called deceitful means. So these are the two ingredients, either this should be there or this should be there for abduction. Either you are by force made to move from one place to another, or either by deceitful means you are made to move from one place to another. Okay, means induces a person to go from one place to another. Okay, now one place to another, that is sufficient. It is not that someone is being kidnapped and put into the foreign location. No, it can happen within India, within state as well, within a same district as well. Someone can be confined, someone can forcefully be abducted and put in a separate room in the same street. Okay, or someone can be made to move and kept there as a slave somewhere else. Okay, then the offense of abduction is complete. Okay, now here in contrast with the law of kidnapping, okay, law requires mens rea. Like we discussed in kidnapping, no mens rea was required. Just simply taking someone out of the lawful custody will make a person guilty of committing kidnapping. But here, simply because someone has enticed someone, or someone has taken someone out of somebody's company, or someone has made someone move from one place to another, will not count as abduction. Okay, here the law requires that there has to be mens rea as well. There has to be a mens rea as well. That means either you commit it by force or you commit deceitful means. When someone is using force, that means he has an intention to use force, isn't it? And when someone is using deceitful means like this, that means he has an intention to cheat someone else. So these are the mens rea, ingredients of mens rea, which we require in abduction. But we do not require mens rea in kidnapping. Why? Because children have a special place in law. Okay, they are considered too innocent. Okay, and that is why we do not require people to prove mens rea when someone is kidnapped. Simply by act of kidnapping is sufficient when the child is taken out of the custody. Okay, that's it. But adults are more sincere and are more intelligent and aware. So law requires that in such cases, if an adult claims that I have been abducted, then he must prove how he has been abducted, whether the force was used, and if the force was used, when was the force used, how was the force used, or if someone is claiming that I have been deceitfully made to move from one place to another, how you have been moved, what was the deceit. Okay, but when a child says that someone took me out, okay, then that is sufficient. Or if a parent comes and says that someone has taken my daughter out, it is sufficient to constitute kidnapping. So this is the distinction between abduction and kidnapping. This is for grown up adults above 18 and those who are not unsound. Sound adults, okay? And unsound adults in kidnapping and minor in kidnapping. Abduction is an auxiliary act and not a substantive offense. Here, hence not punishable in itself. Intention of the abductor is an important factor in determining the guilt. It is continuing offense. Free and voluntary consent condones the abduction. Okay, so abduction is an auxiliary act and not a substantive offense. In kidnapping, we read that kidnapping is a substantive offense. That means the moment you take the child out of the custody of parents, it will become a Offense of kidnapping is complete. But abduction here says it's an auxiliary act. Auxiliary act means act is not punishable. Taking someone from one place to another itself is not punishable. Okay, but it can become an offense when it is accompanied by these things. Merely taking someone from one place to another, an adult person, will not be an offense. In kidnapping, merely taking child from the custody outside the custody is offense. Okay, but here abduction is not that offense in that sense. It's an auxiliary act, and it is not punishable in itself if someone is taking someone to another place. Okay, but in kidnapping, if you take a child out of their parents' custody, whatever be your intention, you are guilty. Okay, here intention of the abductor is important factor. That whether the abductor, who is supposed abductor, he wanted to abduct or not. If he did not want to abduct, he has committed no crime. Okay, but in the case of a child, in case of kidnapping, we do not go into the question of whether he wanted to abduct or not. Simply because he has taken the child out of the custody, he is guilty. Okay, this is the distinction between abduction and kidnapping. It's a continuing offense. It's a continuing offense. Okay, it will keep on continuing till the time you do not leave him. Okay, till the time you do not leave him. Free and voluntary consent condones abduction. Free and voluntary consent. Someone has abducted you and keeping you forcefully there. But when the police comes, you say, no, I'm living here by my own choice. Then there is no abduction. Okay. Then the offense of abduction will be condoned. Condoned will be means foregone. Forgiven. Okay. It will be forgiven. But not the case of kidnapping. In kidnapping, even if the minor child says that I went with my own violation, with my own consent, then also it will be treated as a violation. It will still remain an offense only. Okay, offense of kidnapping cannot be condoned by the child simply by saying that I had given my permission for such. Now we move on to obscenity and sexual offenses. Another kind of offenses. We are now done with major portions of offenses against human body. Okay, see, law is very detailed. We cannot discuss all, but we are discussing only what is major and which have most probability of being asked in the examination, and historically which has been traditionally asked more. Okay, those chapters only we are doing. Now let's move on to offense of obscenity and sexual offenses. Okay, obscenity. What is obscenity? Obscenity Obscenity means an act which is so prurient in nature that it shocks the morals of society, or the act has intention or effect of depraving the minds of reasonable man. Okay, obscenity means an act which is so prurient in nature, which is so prurient or sexual in nature that it shocks the moral of society, or the act has intention or effect of depraving the minds of reasonable man. Okay, some act of nakedness. Okay, and obscenity can be by video, audio, photo, written text, etc. Obscenity or obscene acts can come in the way of through videos, audios, photos, written texts, or sculptures, or anything. Okay, there is no set definition of what is obscenity or what is the medium of carrying obscenity. Okay, so obscenity means an act which depicts a sexual act, okay, or describes a sexual act, but it describes it in such a nature, okay, it describes it in such a nature that it leads to deprivation of the mind of a reasonable man, okay, or it shocks the morals of the society, okay, it is so sexual in nature and so vulgar in nature, okay. Every society has its own standards, okay, so we follow the society standards of the society. Okay, and what are the standards of the society? They are not defined here. Okay, they depend on case to case basis. Like in America, like in USA, people may be more mature or more welcoming to such acts. Therefore, like in USA, people may be more mature. Okay, when I say people may be more mature, I do not mean to say that we Indians or people living in the Middle East or other countries, people are not mature or people are insensible. No, I'm not saying that. I'm saying maturity in terms of obscenity. They may be more mature in terms of obscenity. Okay, they are more accustomed to these things in the movies or text. So they may be there. It may be a general standard. Okay, the way they dress, the way they live, the way they kind of serials or videos they watch, and kind of the law there. Okay, there are so many factors which go on to involve a moral code of the society. So USA obscenity may have a completely different context. In Middle East countries, it may have a complete different notion. In India, it has altogether a different notion. And in India as well, within India, there may be different notions. There may be different notions of obscenity, such as it may be different in metro cities like Chennai, Delhi, Mumbai, etc. It may be different in a remote village. Okay, so obscenity is a changing term. Obscenity is a evolving term which keeps on changing with time and society concerned. Okay, so there cannot be a perfect or a fit definition of obscenity which fits in all situations. What is obscenity? Okay, so now you understand what I'm talking about. Obscenity, generally, obscenity is so prurient or a sexual act in such a nature, depiction of sexual act in such a nature that it shocks the moral of the society, or the act has intention or effect of depraving the minds of a reasonable man. Reasonable man is not someone who is very intelligent. Reasonable man is just like any other common man. Okay, when we consider reasonable man, we are not talking about movie star or something else or a politician. No, we are talking about a common man who lives commonly in the society. What are his standards? Okay. Okay, the first offense. Okay, first offense when it comes to outraging, when it comes to sexual offenses, is outraging and insulting the modesty under IPC section 354, 354A, B, C, D. Okay, what is outraging and insulting the modesty of a women? Now, outraging the modesty of women is dealt in within section 354 and 354 A, B, C, D. Now, new sections have come up. These sections deal with what is outraging the modesty of a women. Okay, it says whoever assaults or uses criminal force to any woman intending to outrage, either he has an intention to outrage or knowing or has a knowledge that what he is doing will outrage her modesty, shall be guilty of outraging the modesty of women. Okay, and it has a very severe punishment up to 7 years. Okay, in some states. Okay, 7 to 10 years. It depends on state to state. Okay, different states have different punishments for such cases, and punishment can be from 7 to 10 years, and it is a very serious offense. Okay, now let us see again. Whoever assaulting means, like we have discussed, whoever uses such words, okay, or behave in such a manner. Assault and battery, we discussed it in law of tort. Okay, assault and battery we discussed in law of tort. Now, assault means when you do not touch someone. Assault is you are not touching someone physically, but you use your body, your gestures, your objects, other objects in such manner. Okay, or uses criminal force. Okay, or forcefully doing something with a woman without her consent. Okay, forcefully doing something. It may be an act of touching, it may be an act of grabbing, it may be an act of holding her, doing whatever without her consent. It is straightly going to land in jail without any bail. Okay. Whoever assaults or uses criminal force to any woman. Now it says any woman. It does not define what woman. Okay, it doesn't define what woman. That means all women right from birth till date, irrespective of age and condition. Okay, irrespective of age and condition. Okay, we are talking about women only. We are not talking about a mature woman or a minor or an old. Okay, any woman. It says any woman, a baby girl of 1 day old, just born yesterday. She is a woman for this section. A 99-year-old woman. Okay, she is a woman for this section. Okay, there is no distinction based upon the age or qualification or anything. Any woman, that's it. Whoever assaults or uses criminal force to any woman intending to outrage, you have an intention to outrage. Okay, you have an intention to outrage. Okay, to take away. Outrage means you are taking away, you are violating. Outraging is okay, violation. You are violating her modesty or knowing it to be likely or that this act or you have a knowledge that this act will lead to violation of her modesty shall be guilty of outraging the modesty of men. Now, what is modesty? What is modesty? It is very complex term. Difficult to define. Okay. It is difficult to define. But Generally, we can say a woman by birth has certain way of carrying herself, okay, and no one is allowed to do anything which outrages that modesty. Now, what is modesty? It is a very complex term. Okay, every woman has a way of carrying herself, and no one is allowed to violate that space. Okay, that is an aura a woman has around her. Okay, that is modesty. The way she carries herself, that is the modesty. Even a 1 day old girl, she is no conscious about her body or herself, but she also has a modesty. Okay, 99-year-old lady, she has no interest at all, okay, in maintaining herself, but she still carries her modesty. It is something, it is something or some energy which is in a girl or in a woman right from her birth and stays with her till the time she dies. Okay, that is modesty. Okay, that is modesty. So, whoever assaults or uses criminal force to any woman intending to outrage or knowing it to be likely that he will thereby outrage her modesty shall be guilty of outraging the modesty of women. We can say, like, A really follows B when she goes to tuition and blocks her way and asks her to talk. Okay, modesty is outraged. A is a boy who is following a B. B is a girl who is going to tuition. Now he has taken the note of her timetable at what time she goes to tuition, at what time she comes back from the tuition. He is every day following her. And one day he blocks her way, doesn't let her leave. He blocks her way and ask her to talk to him. Okay, that you should talk to me. Now he is trying to assault. He is blocking the way. He is assaulting. He is using a criminal force as well. The girl is threatened. This is an offense. Modesty is outraged. Okay, modesty is outraged. A he has outraged the modesty. Okay, so what may be an outraging of the modesty and what may not be an outraging of the modesty? It all depends on the case in cases. Okay, but generally, it can be said that the act should have a sexual undertone to it. Okay, then any act, okay, showing a picture to a girl without her consent, clicking pictures of a girl without her consent, making any gestures towards girl without her consent. Okay, so all these can be the all this can be outraging of the modesty. Even staring at someone, you are staring at a girl for more than 20, 30, 50 seconds. She has asked you not to stare at her and you are still staring at her. This violates her field. She has a field around her. You cannot violate into it, that field. You are outraging her modesty. You are assaulting her, knowing it likely that you will outrage her modesty. So modesty has been outraged. Okay, that is a very serious offense. Okay, no one should indulge in such anti-social behavior. So this is called outraging the modesty. Clicking somebody's videos, putting someone's video on internet, obscene video on internet, morphing a girl's picture, okay, making a girl's picture, taking a girl's picture from a social website and doing something with the photo and then putting it online. Okay, that is also outraging the modesty. So modesty can be outraged in so many ways. Okay, there cannot be a definition of how a modesty can be outraged. Any act which where you are using assault or you are using a criminal force with the intention, or when you know that this act is going to likely to have that effect, then the modesty is outraged. There was a celebrated case of Rupan Deol Bajaj versus KPS Gill. This girl Rupan Deol Bajaj. This Rupan Deol Bajaj was a senior IPS officer, and this person KPS Gill, he was a Director General of Police, DGP. That is the topmost cop of the state, Chief of the State Police Department, a gallantry winner for fight against terrorism, and a highly decorated and celebrated police officer. Such was the stature of this person KPS Gill. Okay, such was the stature of this person KPS Gill. Now, what happened in one night? There was a party. Now you see the facts of this case. Rupan Deol Bajaj versus KPS Gill. What happened in this case? This person, Rupan Deol Bajaj, was the senior IPS officer, like we discussed. KPS Gill was the DGP. So KPS Gill hosted a party at his house because he was the DGP. Okay, he called all the senior officers of the police, and all the senior officers of the police went there. Okay, because it is their chief's party, so no one usually denies the invitation. So they went there. But at one point of time in the night, what happened during the party? This Rupan Deol Bajaj was standing, taking her food or whatever she was discussing with somebody, something. This KPS Gill comes and tells her that you come and follow me to upper floor. Okay. Now this Rupandel Bajaj sensed something wrong in KPS Gill's intention and she refused to. Then after some time KPS Gill again came back. He gently slapped twice on the back portion of Rupandel Bajaj in front of all people and asked her to follow her. Okay. She was violated. She felt very outraged and she went to file a police complaint. Okay, she went to file a police complaint. A senior IPS officer went to file a police complaint against the police chief. Police refused to file a complaint. Police refused to register a complaint. Okay, as this was against their own chief. She went to court. Complaint was registered. She went to court. The police complaint was registered after the court gave directions for registering of police complaint. Now, she went to police. She is a senior IPS officer and she goes to a police station to register a complaint. And what is the complaint? That she says that I have been violated. My modesty has been outraged. By whom? By KPS Gill. So, police station refused to register a complaint. Why? Because definitely he was the chief. So, they did not have the courage to register a complaint against their own chief. So she went to the court, and on the instructions of the court, a police complaint was registered against the KPS Gill. Okay, now police investigated the matter and gave a clean chit to KPS Gill. Police said that no offense has been committed. Okay, when no offense has been committed, when he gently slapped at her back portion, he had no bad intention. He had no bad intention. The police said so. Okay. Court also acquitted KPS Gill. Lower court acquitted KPS Gill. She appealed in the High Court. High Court too acquitted KPS Gill. See what is happening here. This man has, without permission, and in that too in a full blown party of all the police officers, he gave two slaps on somebody's hips. Okay, on some women's posterior back portion, and then neither the police is interested in registering a complaint, and when they are directed to do so, they are giving a clean chit for this offense. Sessions court is not taking it as an offense. High court too is not taking it as an offense. Why? Because this person was highly influential person. He was a DGP of the state and he had a big role in eliminating all the terrorists from the Punjab. If you people have studied in 1984, in 1980s, Punjab used to be a hub for terrorist activities, and this is the person who is revered, okay, for removing or for eliminating all the terrorists from there. So he was very much revered. He was very and people hadn't had a general fear of him as well. He was being feared by people as well because he had removed the terrorists. Okay, so he had a fearsome image as well. So even High Court said that no offense is committed. Now we read it. Simply by reading, we all can understand that an offense has been committed. And look at the courage this girl, this lady officer, Rupandel Bajaj, showed, that in the circumstance she went against her own chief. And she not only went against her own chief, but she went to the court on different levels. She first went to the court to get the police complaint registered. Then she again came to the court, but KPS Gill is acquitted. She went to the High Court. Then KPS Gill is acquitted, and she still did not like give up the fight. She approached the Supreme Court. Now finally, what Supreme Court held? Supreme Court held in favor of Mrs. Bajaj, Mrs. Rupandel Bajaj. Finally she succeeded in Supreme Court, and Supreme Court said that act of slapping on her posterior in front of guest cannot be called a gentle act. It is definitely you are using a criminal force. You are using a criminal force and you have a knowledge. You may not be intending. Now, the argument before the Supreme Court was that there was no intention to outrage the modesty. Supreme Court said that you may not have the intention of outraging the modesty of Mrs. Bajaj, but your act in front of guests, even if she is alone, your act is sufficient to give you an alarm that doing so will outrage her modesty, and it amounted to outraging the modesty. Okay, but and KPS Gill was found guilty. Okay, so see, and how this law has developed, evolved. Okay, after this particular firebrand case. Okay, this law has been there right since 100 years. Okay, more than 100 years, but because Indian society was such that women were so bashful, or they did not have the support from the previous times I'm discussing. Okay, 20 years back, 30 years back, society did not support women coming out or going to the police station, and it was all panchayat system or male dominated society, so people would usually not believe that someone is violated. Okay, so these were the situations. So she paved the way for all the women, and she actually showed people that yes, if you are going to violate a modesty, your law is going to take an action against you, even if you are the topmost police chief, biggest police chief of the country. Then also, so this is outraging the modesty of women. After outraging the modesty of women, it comes the offense of rape. Okay, offense of rape says whoever has sexual intercourse with a woman. Now, what is the offense of rape? It says whoever has sexual intercourse with a woman under the circumstances falling under any of the following seven descriptions. Okay, if someone is having a sexual intercourse with a woman, okay, that means there can be no rape of a man. Okay, there can be no rape of a man, only it can be a rape against a woman. Okay, man cannot be raped. Whoever has a sexual intercourse with a woman under the circumstances falling under any of the following seven descriptions. Okay, if you are having a sexual intercourse with a woman, okay, and we are talking about sexual intercourse, that means the offense which we are talking about, rape, can only be committed by a man, and the victim could only be a woman. Okay, now you people must be thinking that what kind of statement he is making. This is very obvious. No, this is not very obvious. Okay, because now society is changing. Different forms of offenses have come out. If you go to some states, some other countries, then offense of rape can be committed even by a woman, and rape could be conducted even upon a man. Okay, so now because the law is a evolving subject, we are evolving with the society. Okay, but anyhow we are still following this definition. Okay, so it says whoever has sexual intercourse. Okay, so if you are having sexual intercourse, if you are having a sexual intercourse, it will be rape. Whatever you are doing with a woman other than sexual intercourse, okay, other than sexual intercourse, will go into this punishment, outraging the modesty. It will go into outraging the modesty. Okay, and whatever regarding sexual intercourse you are doing with a woman. Okay, and intercourse has a very wide definition now after 2013 amendment. Okay, after 2013 amendment, that means okay, it has become very wide definition. Okay, and we no longer follow the traditional definition of rape. We no longer follow the traditional definition of rape, and the definition of rape has become very wide with the change of times now. Okay, so anyhow, whoever has sexual intercourse with a woman under the circumstances falling under any of the following seven descriptions. So any circumstance which follow within those seven cases, within these seven categories, even if one of them categories a woman is about can put her case, then the man is guilty of committing rape. Now, what are those seven categories? Let us say against her will. Okay, against her will, without her consent. Okay, against her will and without her consent. With her consent, when her consent has been obtained by putting her or any person in whom she is interested in fear of death or hurt. Okay, when you are taking her consent, when she has given the consent, but such consent was obtained by putting her or any person in whom she is interested in fear of death or hurt. Okay, in fear of death or hurt. If you are saying that I'm going to hurt your husband, your brother, your son, your friend, and this and that, and she is interested, and then you are making her submit to your consent, okay, submit to your temptation, then that still will be rape. We will not count this consent as a genuine consent at all. With her consent, when the man knows that he is not her husband and that her consent is given because she believes that he is another man to whom she is or believes herself to be lawfully married. Okay. Now, the rape, sexual intercourse is committed with a woman with her consent. Okay, with her consent. But she has given the consent believing that the person who is taking such consent is her husband, but he is actually not her husband. Okay, he is not actually her husband. Okay, now this is somehow very archaic category now. It is not much in use, but yes, now you people must be amused that how a woman may not know her husband. But yes, this law is a century, more than a century old law, and India there used to be child marriages, and there used to be marriages where women did not get to see the husband before marriage, or ceremonies used to be such that even during marriage ceremony she did not have good occasion to see husband carefully. There used to be child marriages. Okay, there used to be child marriages. A woman was not aware who am I married to. She did not know her husband. Or when it used to happen, it used to be arranged marriage. If you go back to era of 1960, 1970, there was no cameras that time. And if cameras were there, very less people were interested. Okay, so there used to be no photographs. Only families used to see. Okay, women was not allowed to see the husband before the marriage, and even some ceremonies in some situations were so that woman used to be thoroughly covered, man used to be thoroughly covered, okay, with their attire, and they did not get occasion to see each other. Okay, so in such situation, if someone pretends that I am the person whom you are legally married to, and then she has given her consent, but the man knows that he is not the real husband. So this case is applicable to that category. Nowadays we do not have cases under these categories too many. Okay, but still it is there. With her consent, but at the time of giving such consent, by reason of unsoundness of mind or intoxication, she was either unsound. She gave the consent, but she was unsound when she gave the consent. So we know in the law, unsound mind people cannot give a valid consent. Okay, so she was unsound. Okay, you can take consent from an unsound person for anything. Or intoxication. She is intoxicated. Now, here we are not talking about self intoxication or intoxicated by someone else. Okay, intoxicated by someone else. Here we are not making any distinction between whether she was self intoxicated, whether she consumed liquor on her own, or she got intoxicated due to taking drugs or liquor on her own, or somebody else out of force or out of cheating gave it to her. Okay, we are not concerned with that. If when she gave the consent, she was intoxicated and she later on says that my consent was not
It's
taken
6 o'clock.
voluntarily, then definitely it is a rape. Or the administration by him personally, or through another of any stupefying or wholesome substance. She is unable to understand the nature and consequences of that to which she gives consent. Okay, or something is administered to her in which she is not able to give a consent. She goes to a doctor. By saying something that this will treat you and something like, okay, she is now under a drug which a doctor has given to him, so she cannot give a valid consent. This is a rape. Okay, with or without her consent. When she is 18, she is under 18 years of age. If she is below 18, it doesn't make a difference whether she has given a consent or not. If she, even if she comes to court and says that sexual intercourse between me and him happened with my consent, and in fact I was the one who invited her, or I was the one who instigated the act, then also, because she is under 18, we do not believe a girl below 18 competent to give the consent. So if any intercourse with a girl who is below 18, then no consent at all when she is unable to communicate the consent. When she is unable to communicate the consent. Okay, when she cannot communicate the consent, she is ill. Okay, maybe mute, may not be able to speak, she may not have voice, maybe a patient under coma, maybe an maybe a newly, maybe a small child aged 1 year unable to speak. Okay, there may be so many conditions in which a woman may be unable to communicate consent. Okay, she may be injured. Okay, she may be a patient under coma, she may be in the vegetative state, she is a small child, she cannot speak, she is ill. Okay, so many conditions can be there in which a woman may not be able to give her consent. So, in such cases, if someone is committing sexual intercourse with her, then definitely he is committing a rape. Okay, now again come back to against her will, without her consent. Against her will and without her consent. Against her will and without her consent. What is the difference between both these things? Okay, against her will or without her consent. What is the difference? What is the difference? Okay, now the difference against her will is that you are, first of all, against her will means directly raping someone by using force. You are straight away using force. You are muzzling her voice, you are using your body, you are forcing yourself on her, you have tied her up, or you have kidnapped her, or you are doing whatever, but against her will, you are by force, you are using, by force you are committing rape. Without her consent covers all those cases. Your consent may be obtained by force, fraud, deception. In such cases, without her consent means that yes, she has given a consent, but her consent is obtained by committing fraud or deception upon her. She has not given you a valid consent. Her consent is obtained consent. She goes to a Baba. I am not getting a child. Baba says you have sex with me, you will have child. Something like this. Okay. In this case, now she gives consent to Baba to have sexual intercourse with her. But her consent is not a valid consent because she is a gullible lady. Baba has now deceived her. Okay, Baba has now deceived her by she is believing in the magic of the Baba. Okay, that Baba is some god man and this and that. Okay, this is not the case. This cannot be the valid consent which we are talking. Okay, she wants a job. He promises a job for sex and she has given a consent. Okay, because she is very poor, she wants to maintain her family. Okay, so she thinks that he will give a job. She has given a consent. She has given her consent, but this consent is not a real consent in the law. Okay, this consent is not a real consent in the law. Clear? So these are against her will is directly forcing. Without her consent is that though she may have given her consent, but consent is given in such situations. Okay. Provided that a woman who does not physically resist to the act of penetration shall not by the reason only of that fact be regarded as consenting to sexual activity. It further says if a woman simply because simply because a woman did not physically resist it, she did not react to it, or she did not protest the sexual act with her, she did not protest, this thing shall not automatically mean that she has given a consent. She has not protested, that is one thing, okay, we can consider it, but simply someone is trying to say because she did not resist when we were entering into a relationship, that itself means she had given a consent. No, that is not the consent we are discussing here. Consent has to be valid consent. It has to be vocal consent. Okay. Exception: a medical procedure or intervention shall not constitute rape. Exception 1 is a medical procedure or intervention shall not constitute rape. If you are conducting some medical procedure, that is a genuine, authentic medical procedure. You are inserting something, okay, you are inserting some surgical plates or some part, you are tearing up on the body and doing something with the body. It shall not be it shall not constitute rape. Sexual intercourse or sexual acts by a man with his own wife, the wife not being under 18 years of age, is not rape. Okay. If you are married and your wife is above 18, it shall not be rape. But if wife is below 18, it shall be rape. Okay. If you are married, your wife, if she is below 18 and you are entering into sexual conduct with her, it will be rape. If she is below 18, then sorry, if she is above 18, then it won't be a rape. Consent on the pretext of promise of marriage. Dilip Singh versus State of Bihar. Such promise to marry would be punishable only if it is established that from very inception man never really intended to marry. If not, then he could be liable for breach of promise. Now, this is a case in which, now there are so many cases in which girls have come up to the court saying that my boyfriend raped me. How he raped you? Because the sexual intercourse happened with the consent, but he said he would marry me. Now he is not marrying me. So he has raped me, he has not taken the consent validly. So the Supreme Court has said that such promise to marry would be punishable only if it is established that from very inception man never really wanted to marry. That from the day of relationship itself, from the first day, man had no intention to marry the woman. Okay, and he was just for getting sexual favors. He was playing this trick that I will marry you later, and later now he says I won't marry you. Then it will be rape. Okay, but if There was no such promise. Okay, and two adults enter into a relationship together, and later on they are having a fallout, it won't be a rape. False promise of free marriage will not ipso facto make a person liable for rape if woman is above 18 years and impliedly consented. Women cannot be charged for rape, however, they can be charged for abetment of rape. Abetment of rape means instigating someone to commit an offense. So, if women instigate someone to commit rape to someone else, she can be charged as an abetter of the rape, but women cannot be charged for rape. Why? Because I discussed rape in India, we mean only man to women. Now, these are some case laws which we are going to discuss in the next class.